I'm sorry the court's sitting a little late.
May it please you, my lords.
Yes.
I appear for the appellant, and Kevin Powell and Sundiata Gibbs appear with me. My name is Michael Newton. My learned friends, the Honorable Attorney General, Marlene Malofu Ford QC, and Althea Jarrett appear for the first to fourth respondents, and my learned friends, Dr. Lloyd Barnett and Annalisa Lindsay, appear for the fifth respondent.
Yes.
Let me start by establishing what we are not arguing. The respondents and the courts below spent some time in repeatedly stating that the company continued as an entity, that the company continued to be bound by previous decisions, although there was a change in ownership. And I'd just like to start by saying, my lord, it has consistently been our position that we accept that it is the same company, we accept it is bound by its decisions, and of course, my lords, it is because it is bound by its decisions why it paid the retroactive salary increase.
Yes. Right. Well, that's a good point to clear out of the way.
Yeah. So the primary question on this appeal, of course, is whether the term managerial decisions in the context of the Z-factor provision in the license was meant to capture and include decisions.
Should one not see this case perhaps the other way round? You say that's the primary point, but if these costs were known and measurable with reasonable accuracy at the commencement of the quinquennial 5-year period in 2004, and were costs which were taking effect within 12 months, if that adds anything. If they were, then they should have been included in the 5-year program, and in that event, you couldn't recover them as Z-factor costs. If you can show that you're entitled to say that they weren't known and measurable with reasonable accuracy, and there appears in the Court of Appeal and probably the Tribunal, and we'd have to look at the office, but there appear to be some findings or conclusions against you on that point. But if you win on that point, then we move to the Z-factor point, and we ask whether this is something occurring during the 5-year period, which is what the Z-factor is meant to deal with, isn't it? Or it's meant to deal with the annual review.
Yes. Yeah. Your Lordship is correct.
And we ask whether it can sensibly be attributed to a managerial decision.
Yeah,
in the present case, I mean, it seems to us that you've got a situation where there might be an oddity, because it's not suggested that they couldn't have been included in the 5-year program if they had been known and measurable with reasonable accuracy and were to take effect within a 12-month period. They should then have been part of the test year, and they would have been included and recovered. So despite the fact that they all arose from these managerial decisions, in inverted commas, going back to 2000.
Yeah, and if
so why should they, I mean, you're entitled to ask perhaps at some point in the argument, why shouldn't they be recovered? Why should it be a bar to recovery if they weren't known and measurable with reasonable accuracy, so they couldn't be included in the 5-year program, if they subsequently emerged? Anyway, that's at least to my way of thinking, a point which or points which you have to deal with, and which is quite helpful to think about in that order.
Yes, and I think effectively your Lordship is saying that logically what has been described as the second issue is the first issue.
Well, I think I am probably saying that, yes.
Yes, and my Lord, I'm happy to approach it that way and to deal with that issue first, because I appreciate that.
Well, it's up to you which order you take them in, but it sounds as if you've been thinking along similar lines.
Yes. Well,
Do whichever way you find most convenient.
I must say, for my part, I would certainly find it convenient to understand how the scheme works, because, I mean, if it's right, as my Lord says, that as at 2004, if you've been able to bring these, been able to measure these accurately as, then is it common ground that you would have been able to bring them into account at that stage?
yes, my lord.
And the fact there were managerial decisions wouldn't have mattered.
Yes, my lord.
So, I mean, that seems to be quite an important starting point for considering the construction of managerial decisions when we come to the Z factor. But
I would observe, my lord, that one of the perhaps curious things about this case is that the tribunal held, that is the appeal tribunal, held that criteria A and C of the Z factor provision had been satisfied,
Right.
and that the only issue was the issue of managerial decisions. And that is how the matter progressed in the other two courts below. Everybody proceeded on the basis that the only issue was managerial discussions in terms of criteria under the Z factor.
And do you say, did the Court of Appeal go back on that? No, it didn't.
Well,
Anyway,
shall I
yes, sorry.
tell your lordship where that can be found? Or,
I was asking whether the Court of Appeal took a different decision from the one which the tribunal took on that.
no, my lord.
No, I mean, so there's no question that the events affected the costs and weren't captured by other elements. That's A and C.
That is what was held, my lord.
So the whole
Specifically.
thing was about B.
It was, my lord.
Yes.
Yeah. But what about my Lord's point then? Shall we take, as you were willing to do, take what now seems logically the first point?
Yes, my lord. My lord, in relation to that, then the issue of the, in 2003, or prior to March 2004, it could be said that these costs were known and measurable and to be included. May I just start with a word, my lords, on the issue raised by the respondents of there being concurrent findings?
Well, what does it mean by concurrent findings here? Tell us more about the role of the tribunal here, because there are some statements about it in the license itself. Is there any more general law on the subject, or do we just gather the role of the tribunal from the license? Because the license describes it as an appeal tribunal, but at the same time it suggests that its role is simply to have regard to the legality, rationality and procedural propriety of the office. In other words, it's not a rehearing on the facts. What is it?
Well, my lord, the tribunal has heard two appeals. Had heard an appeal prior to this one. It heard an appeal
Yes.
prior to this one and this one. That issue was raised before them. And in both cases, they held that they were effectively an appeal, not a judicial review type hearing. And
Do they hear fresh evidence then?
yes, my lord.
Or are they an appeal in the strict sense, not hearing fresh evidence?
Pardon, my lord?
What do they mean by saying they're an appeal tribunal?
My lord, if I could take you to page 191.
191.
191, my lord. That's where they address this issue. On 191, the tribunal quoted from the license and then said, the tribunal regard its procedure as that of a general statutory appeal process due to its power to confirm, modify, or reverse the decision while observing, etc. And they underline modify because the point that was made in submission to them, which they accepted, is that in a judicial review, the body usually have a power to modify.
But it this doesn't help on, or does it help on the question, on what basis can they modify? I mean, the first part of the license paragraph says, on hearing an appeal, the appeal tribunal shall have regard to the legality, rationality and procedural propriety of the office in arriving at its decision. So there's nothing there about having another look at the facts. still less about making findings or hearing fresh evidence. So what is your submission about the tribunal's role?
Well, my Lord,
It didn't hear fresh evidence, or did it?
in this case, my Lord, it did not hear fresh evidence.
No.
I mean, there was an affidavit filed in relation to matters that had occurred after the OUR, but there was no specific ruling on it.
So, strictly therefore...
May I just add something, my Lord? As I had mentioned to your Lordship, the tribunal, the same tribunal has heard other appeals in which it has heard fresh evidence.
Well, maybe in this context, under the license, or...
Under the same clause.
Yes, it's a specific tribunal for this particular license, isn't it?
It is, my Lord.
Yeah. So in other cases, you're saying it has heard appeals and heard evidence.
In one other case.
One other.
Did you hear argument on the question, whether that was its function?
There was an argument, my Lord, as to whether it was merely a judicial review type process,
Yes.
or whether it was an appeal, and the section I've just quoted is how that was resolved. That was the extent of their...
Well, maybe it doesn't matter in the present case because it didn't hear fresh evidence, so that on the face of it, it couldn't go further than the office on the facts. Is that right?
But, my Lord, there was some fresh evidence, but
It's a different conclusion.
it didn't play a part in the decision.
Yes. Sorry.
There was fresh evidence, my Lord, but it did not play a part in the decision. There was an affidavit,
Which was that?
which is at page 141. I should indicate, my Lord, that when this affidavit was put before the tribunal, Dr. Barnett, who was counsel before the tribunal for the OUR, objected to it being placed there. There was no express ruling for or against it, and it was included in the record. But as I say, none of the judgment did not refer to it. My Lord, the purpose of this evidence, as we explained in the court below, as the transcript explains, what happened here is that after there was an agreement and a payment as to the amount payable, and a payment was made, the unions made a further claim.
Yes. They said that overtime had to be
Overtime,
covered and so
exactly.
on, and they lost on that. It was
And
told
they
that
did.
it had been settled.
Yes.
Yeah, by a majority, they lost. Yeah.
Correct, my Lord. And they instituted a judicial review proceedings in relation to that decision. The point that we wanted to make and sought to make before the tribunal was that our concern, the appellant's concern, as to the effects of the ruling, which is to say that if we had simply not challenged a claim by the unions, simply accepted their claim and put it in the rate review, it would have been recovered. As opposed to, and the OUR has ruled in this case that having challenged it and therefore not put it in the rate review, it could not be later recovered.
When you say the rate review, you mean for the second 5-year period, do you, or what?
Well,
When would it have gone in, or when could it have gone in?
for the purposes of the present matter,
Yeah.
the fifth respondent's position is that it ought to have gone in the first rate review.
Yes.
But the point we were making is that it would set a precedent for future rate reviews and future similar situations.
Yes.
And so this evidence was to say it was not merely hypothetical, well, nothing more. So that's why I say nothing turns on this evidence. But to answer your Lordship's question, I wanted to ensure that, for accuracy, there was further evidence.
Can I just check one thing? The Court of Appeal noted that no issue had been taken as to the propriety of the tribunal which we're presently concerned, taking into account materials which had been before the Industrial Dispute Tribunal. We have that at paragraph 58 of the Court of Appeals decision. It's page 378. And that's correct, is it? There's nobody was quarrelling with the tribunal, the appeal tribunal in relation to the licence dispute, taking into account material which had been before the IDT.
Well, my lord, this statement is incorrect.
It's incorrect, is it?
In that it says, which included reports from the consultants. Because the reports from the consultants...
Sorry, where's the reports from?
Middle of
Oh,
378.
yes, I see.
Line 10.
Yes. Yeah,
So-
yeah, quite.
So it is correct that there was no objection to the material that was before the tribunal and which it considered.
Right,
But that material, as I recall, did not include reports from the consultants.
right.
You say the consultants' reports, they must have, hang on, hang on. The consultants' reports must obviously have been before the industrial tribunal, that's obvious.
Yes, ma'am.
Were they before the OUR
I am not sure they were before the OUR, my
or
lord.
the tribunal?
They were not before the tribunal.
Not before the tribunal.
Before the tribunal.
Right. And after the tribunal, there's no doubt that the only legal process is judicial review.
Correct, madam.
So the reference to which included reports from the consultants is a reference to material that had been before the IDT.
Yes, madam.
In that respect, there's nothing wrong with it, is there? Clearly, they had been before the IDT.
I think that is correct, madam.
Yeah.
But except it seems to suggest that the tribunal considered the reports,
Yeah, that's
considered
right.
the material that was before the IDT, which included reports from the consultants.
Yes, quite. The question is whether it's before the tribunal,
Wasn't it? No, no.
and you say not.
I think it is common ground that all the material that was before the tribunal is in the record.
Right.
And what we see in the Court of Appeal, if you look at the opposite page, on page 379, is some, paragraph 60, some apparent speculation as to what was in, or would have been in, the KPMG report, which was not seen by anyone.
Yes, exactly.
But the one thing that doesn't appear to have been seen, and which one would have thought was highly interesting in the context of deciding what could and should have been done in 2004, were the audited accounts. I mean, the clear inference is that otherwise we wouldn't be here. These costs were not in the audited accounts, because if they had been in the audited accounts for 2003, they would have appeared in the quinquennial review programme for 2004 to 9.
Well, my lord, I think it was not disputed that they were not in the annual accounts, in the audited accounts. Indeed, there's an affidavit that says so.
Yes, I see.
So that affidavit, at page 3 of the record, my lord, paragraph 8.
Page 3.
Page 3, my lord. At paragraph 8,
Sorry, which page are we on now?
3, my
Page
lord.
3.
3.
3.
Yes.
Yes. Your lordship will see at paragraph 8.
So what was the issue before the office, the regulator, and subsequently before the tribunal? Was it whether the company could have included a sufficiently accurate provisional sum for the liability in the quinquennial review of 2004?
Effectively, my lord, yes.
Do you agree, I mean, I'm not sure where you stand on that. Do you agree that if you could have done, you lose? Or not?
My lord, I don't accept that, my lord.
You don't?
I do not, my lord, for the reason that as I had said earlier, the tribunal held that I couldn't. The tribunal held that item C, criteria C, had been satisfied, and that was not disputed.
And you said, well, no, They can't have said that because they also specifically said that you could have included them in the 2004 quinquennial review. It may be that the two findings that C is satisfied and that you could have included it in the 2004 review are, on your submission, inconsistent with one another, but, but they certainly said both, didn't they?
Yes, they did say both.
Yeah, I mean, we'll have to look at the office's reasoning rather closely, won't we? Because, and possibly at the arguments, we've got your submissions. Do we have, to the office, do we have a response submission from anyone? From the other side? In order to see what the other side were arguing?
No, well, there's no other side at that stage, my lord. The office then made its determination.
I see. So there isn't another side. So the question is whether the office has made a finding against you that these sums could have been introduced. They were sufficiently known and measurable with reasonable accuracy.
They did make that
coming into effect.
They did make that finding.
Well,
and my lord, I'm certainly prepared and propose to address that issue head on and to say why we say they could not have been.
yes, I see.
But
We'll have to look at it, right?
yes, but in answer to my lord's question, I would not concede that I lose if I don't. For the reason, and if your lordships, for completeness, I think I should show your lordships the relevant finding by the tribunal, which is at page 205. At page 205, at paragraph 39,
Yes.
the tribunal stated the conclusion in this way. And each of the courts below, indeed, my lord, for completeness, if your lordship goes to page 330, at page 330, at paragraph 72, this is the judgment at the first instance. At paragraph 72, the learned judge merely repeated the tribunal's finding.
Yeah, so you say the critical finding was actually a different one about managerial decisions. Yeah. But we've got to, I thought we were on the...
Hang on a bit. I'm sorry to be slow still. It's entirely my fault. But where in the tribunal decision, which begins at 185...
At page 205.
No, I've got that. Where do they deal with the proposition that you should have included these costs in the 2004 figures? Is it paragraph 35?
Well, yes, ma'am. Well, starting from 34.
34,
Yes.
35, yeah.
Yeah.
So they are finding
Perhaps 33, yes.
that you had enough information to have calculated the cost with reasonable accuracy, as per page 32 of the bundle, and include it in the 2004 application. Now, how does that stand with paragraph 39, the finding that ZC
Yes.
is met?
My lord, they do appear to conflict. There is a way in which they can be reconciled, and it was not clear to me whether when, in the fifth respondent's case, they made the observation that my lord just made, which is that the appellant must succeed on both. The first time that point was being made in that way. Now, it was not clear to us whether it was being argued that, for example, that by not including the costs when you could have, that was in itself a managerial decision which would qualify under B. So that that could have been a basis on which, although the only issue was B, managerial decision, this finding as to your not including the costs was relevant because it was itself a managerial decision, so that it does not necessarily conflict with a finding that C was satisfied.
Right.
And I came prepared to answer that, if that was the argument, and perhaps I'll just address that briefly.
Am I right in remembering that the regulator, the office, made the point that the system does not allow for what I think it called a carryover or a carry forward? Am I right that they made that point?
It's 126.
Next, do you agree that the scheme doesn't allow a carryover, or don't you?
It doesn't envisage a carryover.
It does not.
No, my lord.
Doesn't it follow from that that if you could have put this expenditure into the 2004 quinquennial submission, but didn't, you must lose?
No, it's a different point for this reason.
Ah.
And my lord Mans, I think twice said, known and measured and effective, which of course is what the clause speaks to.
Effective within 12 months.
Effective in 12 months. For the purposes of including it, it need not have been effective by that date. It could be effective 12 months afterwards. But for the purposes of the carryover, it would need to be an expense in that period. The carryover point doesn't arise at all, my lord, for this reason. The carryover point is you can't incur an expense in one period and seek to recover it in a later period, as I understand the point.
Yeah.
But this expense was not in fact incurred until 2008. So that I don't think the carryover point takes them any further.
But are you saying it wasn't effective in the year? Is that
Exactly.
that even if it could have been calculated, it wasn't effective in the test year?
It was not in fact effective in the test year. And the point I'm going to go on to make...
Was that point addressed by the tribunal?
It was not addressed by my lord in those terms, no. And indeed, my lord, that aspect of the issue, of the matter, when the expenditure, the liability became effective, you will see was not addressed in either judgment.
When do you say it became effective?
In May 2008. But, my lord, may I then address this issue of whether we could have and why we say we couldn't?
Sorry, say that, which issue?
The issue as to whether we could have included it?
Yes, quite.
And why we say we couldn't.
Yep, right, yep.
And if I may indicate, my lord, the Court of Appeal's findings. So your lordships have seen what the tribunal said. What the Court of Appeal held on this point is at page 384. And at 384, starting at the top of the page, this is Justice of Appeal Phillips' judgment. By the time JPS had resigned itself to the style structure contended for by the unions, and this, my lords, would be in 2007 after the Court of Appeal judgment. Yes. It may have been prudent to carry out another market survey, as this would have been almost 6 years after the KPMG report. Salaries would not have been impacted by the passage of time and perhaps inflation. However, this could not inexorably lead to the conclusion that because of the recommendation that the Oversight Committee be reconvened, a new market survey had been carried out. This is the important part. I therefore do not think that the tribunal was so absurd in its finding that despite the fact that there was no reactivation of the Oversight Committee, JPS could have calculated its costs based on its view of its liability. And it continues. So that the court below took the view, my lords, that having had the decision of the IDT in August 2003, JPS could have calculated with reasonable accuracy, and so on. My lords, we say that it is clear from the evidence before the tribunal, and indeed before the court, it could not have. And if I could take your lordships to the IDT decision, which is supposed to be the basis for this finding. And I would start, my lords, if I may, on page 50. Now, at page 50, the tribunal, the IDT, is reviewing the history of the Oversight Committee and the role it played. And it starts in the middle of the page at about line 12. To ensure transparency and acceptability of the exercise, there was participation and involvement by the stakeholders at all levels. Committees were established, and in particular, the Oversight Committee. The IDT then set out the responsibilities of that committee, including reviewing recommended salary structures and making rulings. And then, in the following paragraph, excerpts from the minutes confirmed that the committee is a decision-making body, etc. So that's how it was as originally established. On page 58, the tribunal, the IDT, then turned to the position following divestment. Under the heading, the role of the Oversight Committee at line 20, the IDT noted that based on the minutes, the role of the committee appears to have changed when Miran took over. Continued to function effectively, and it ends, but in the final analysis, it made the decisions. There was then a development in the meeting on May 9, 2001. The president of the company attended a meeting of the Oversight Committee, announced certain changes. A concern was expressed by the union representative, and then a decision was made at line 18. Decision was made reconfirming the Oversight Committee as a decision-making body, and the president advised that he was comfortable with the project and was committed. My lords, against that background,
Sorry, where was that reference to decision-making committee?
Page 59, line 18, my lord.
Yes.
So a decision is made that it is a
Yes,
decision-making committee.
thank you, yeah. Reconfirming, yeah.
Now, the Oversight Committee is an internal company structure, is it?
It includes representatives of the unions.
Yes, of course it does, but
Yes,
it's an internal company.
It is, madam. It is. Not yet. Then, my lord, in or about May 2002, the KPMG report is received. Well, indeed, if you look at page 60, the last paragraph, you will note that KPMG presented their market survey. And you will also note that there were criticisms by Dr. Hamilton. He made certain comments, and his comments were summarized at the top of page 61. And I don't think we need to go through these for the present purpose, except to note, my lord, that the tribunal then noted at the bottom of 61 that June 13 was the last meeting of the committee. And at the top of page 62, the decision made was that the company would take certain steps, prepare a proposal, and so on. The IDT commented, there is no record to show, and I'm at line 10, that the stakeholders discussed the matter, no record or evidence to show that the implementation of a salary structure to complete the exercise was discussed by the Oversight Committee, which was in fact a decision-making body. Management seemed only to be concerned in implementing a salary structure formulated in such a way as to accommodate their compensation philosophy without considering the stakeholders. So up to this point, what the IDT is pointing out is that historically it was agreed that this was a decision-making body. This was the body that was to determine the matters set out earlier, and that the company sought to make the decisions themselves. And against that background, they made the decision that appears starting on page 64. And on page 64, under the heading, Unnecessary Provision for a Settlement, the tribunal said, there is much work to be done in order to restore the credibility of the exercise. In the making of this award, the tribunal has decided that the Oversight Committee be reconvened, and the consultants who had participated in the job evaluation and compensation review exercise should be part of the Oversight Committee in implementing the award. Now, pausing there, my Lord, they're not only saying that the committee should see to the implementing of the award, but they are effectively changing the composition by saying that the consultants should be a part of the committee. After a quotation from a text to justify their position, they have a heading that says recommendation. Tribunal strongly recommends that the award be implemented with the guidance and expertise of both groups of consultants in conjunction and collaboration with the Oversight Committee, which comprises representatives of the stakeholders.
So the decision of the IDT is that the basis of the evaluation exercise has to be the top
5 to 10.
5 to 10 percentile, rather than the 50 company survey that for which the company had contended. Yes?
Yes, my Lord.
And then these observations are directed, you say, to how that decision was to be implemented.
Well, I'm going to come, my Lord, to the 5 to 10 percentile. But what these show so far are two things. First, that the determination of the amount could not be done by the company. It had to be done by the Oversight Committee. And the tribunal was at pains to say that against the historical background, when the company sought to do it themselves, it was a breach. It had to be done by the committee. So that this is independent of how it is to be done.
But the
And to answer your Lordship's point, what the KPMG report had done was not an assessment of the top 5 to 10 percentile. And to just complete the award, having made these rulings, the committee, the tribunal, then made the award. That's on page 65. There's no issue with B. And the real question is whether A provided a sufficient basis on which a calculation could be made. Now, what they've said...
Just understand one thing. We're talking about a calculation. We're talking about lots of people with different grades. And we're looking at a limited number of companies. 4, is it, within the 5 to 10% percentile? Is that right?
Well, my Lord...
am I right that we are looking with...
I think that's correct, my Lord.
Yes. So, but do we know where in the 5 to 10% quartile? They may all had different pay rates for different grades.
But my Lord, it's a point I make, my Lord, that on the material available here, one could not say that you could calculate... you couldn't say that JPS could do it at all. It would have to be the Oversight Committee. But also, one cannot say that the Oversight Committee could calculate this with reasonable accuracy. My Lord, if I could take you back to page 52 to show you what KPMG did. KPMG's survey not 52. I'm sorry, my Lord. Page 51, I'm sorry. Page 51 at line 15. KPMG benchmarked the company's salaries against 17 local companies selected by the Oversight Committee on the basis of their size, operation, involvement in manufacturing, mining, and service business, and perceived market position. Of the 17 companies, 11 participated in the survey. So that the companies chosen for the survey were not on the basis of the percentile guidelines, if I may call them that.
Right, that's why you lost in the tribunal, in the industrial tribunal.
Yes, yes. But my lords, my point is that what the KPMG did, the basis of the material that they worked with and prepared their report. And of course, the tribunal, the appeal tribunal and the parties were at the disadvantage of not actually having the report, but we have this indication as to what the report was based on. And we then come, my lord,
it's apparent from the last paragraph that what is involved is comparing with companies in the top percentile, or the 5 to 10% percentile, and then some grades may be below what those companies are going, some may be above, and so on. You have to compare grade by grade, presumably, and work out what a fair comparison, which one to take.
Yes, sir. And
which of the 4 companies in the...
And there will inevitably be judgment decisions. Yeah. And that is why this is not merely an arithmetic exercise. And what was said back now on page 65, what was said in paragraph A is not a formula. This statement about implementing a structure which conforms with and maintains the established compensation policy stroke philosophy agreed on by the parties in the 1990 to 91 heads, which is based on a formula of the top 5 to 10 percentile. That's not a formula. And I just observe, my lord, in case it be thought otherwise, the Court of Appeal held that the 1990 to 91 heads of agreement did not say this, did not contain any such formula, so that lest it be thought that that agreement took it any further. This is what they had to work with. It could not be said, my lord, and this is the evidence on which the tribunal and the courts below said, JPS, upon receiving this, could have calculated with reasonable accuracy the amount of the liability. And I say, my lord, there was no evidence to support that.
Well, would you go back to page 51?
Yes, my lord.
And the summary in the last 2 paragraphs of what KPMG had done. Now, they'd done it on a basis that was less costly to the company than the tribunal eventually said the correct basis should have been. But is it an irresistible inference from what's set out there that what KPMG had done was to set out the jobs job by job, compare them with the comparators that they had chosen, and arrive at a conclusion, job by job?
I wouldn't say that's irresistible, my lord. That could have been
because if they had, the next question becomes, once the tribunal has told you, yes, but you've got the wrong comparators, could you inevitably, by substituting the 5 to 10%, top 5 to 10 percentile, have done the arithmetic from their report, but just substituting different comparators? Because that seems to be what either the judge or the Court of Appeal, or possibly the tribunal, somewhere along the line, has concluded you could have done.
My lord, may I just indicate, by way of answer to your lordship, what actually happened in the event? If your lordships go to page 309, and I'm at 309 in the judgment in the Supreme Court. The learned judge recounted from the evidence what happened following the judgment of the Court of Appeal. In paragraph 10 on page 309, she notes the dismissal in 2007 of JPS appeal. And at 11 she says, thereafter, JPS and the unions convened the oversight committee, re-engaged the consultant with a view to implementing the IDT's award. Unable to arrive at an agreement, the matter was again referred to the IDT in March 2008. As a consequence, in May 2008, JPS and the unions executed a heads of agreement resulting in the salary structure of the employees adjusted to conform with the award in 2003. So that it took 13 plus months after all the litigation was ended to get there. And if your lordships go to page 180, 180, there you'll find the agreement to which she refers. So this was the agreement reached after the Oversight Committee had now been reconvened, done its work, done these calculations. So in May 2008, an agreement was signed by the unions, between the unions, among the unions and the JPS, and witnessed by the Ministry of Labour. And your lordships will note that even then,
What's the date of this agreement?
May 6, my lord, 6, 2008. So that the litigation ended with the Court of Appeal in early 2007, March 2007. And it is after going through all the things that her ladyship just noted, in May 2008, we finally get to this agreement. And your lordships will see from paragraph 5 that even then, it was not complete. Even then, the matter had to return to the Oversight Committee, had to return to the consultants. They both had to take further steps before you could get to a position of an effective award, an effective payment, so that payments could be made.
There's another...
My lord,
Sorry, no, you...
finish, my lord. To suggest that on this evidence, therefore, JPS could have done it in the summer of 2003, I say, my lord, cannot be supported by the evidence.
Well, I mean, in a way, it's the other way around. I mean, they could have done the exercise, but it wouldn't have been the exercise which the IDT had required, because the IDT exercise assumed the participation of the Oversight Committee and indeed various processes. So an exercise done by the company of its own volition simply wouldn't have been what was called for, would it? I mean, isn't that your point? It's not that there was no evidence that they could have done it, but they would have been doing the wrong thing.
That's more accurate, my lord.
Can I raise a slightly different point with you in relation to this? Going to what the Tribunal decided, page 202, does seem to me that the Tribunal was indeed thinking along the lines that Lord Hughes put to you a moment ago, that it had recited what KPMG had done, it had recited what was the nature of the difference between the company and the employees, as to the appropriate comparators. And then you get, I think, what are the critical paragraphs, at 33 onwards, referring to the ITD award which we've been looking at. The Tribunal says, JPS was seized of certain relevant facts, which it summarises, and then come paragraphs 34 and 35. The Tribunal is of the view that these are sufficient facts to have enabled it to calculate the cost of salary payments due with reasonable accuracy, despite the fact there's no indication they sought to activate the Oversight Committee, didn't preclude JPS from calculating such costs. The question I want to ask, however, is this, is that's all on the premise that they knew what they had to do because the IDT had decided it. Now, in fact, of course, they challenged it by way of judicial review, and that then went up on appeal. Now, if the Tribunal's approach is right, they knew all they needed to know as a result of the IDT decision, they would have had, wouldn't they, to have accepted the ITT decision and not challenged it, because if they were taking the point the IDT's decision was itself legally flawed, then it might be argued they weren't in a position to calculate their liability. In other words, the IDT's, the Tribunal decision puts them in a catch-22, that you either accept the judgment of the tribunal, right or wrong, and then you can calculate it. If, however, you take the view that you think it's wrong and you challenge it, you're taking the risk by pursuing your legal challenge that if you're found to be wrong, then you've lost the opportunity.
Exactly. I'm allowed,
The gates are closed on you. Now, and you know, can that be a just way of approaching things?
My lord, two things. I'm going to, when I finish this exercise, I propose to go next to the license itself and how it provided for the recovery of costs prudently incurred. And I propose to submit, my lord, that that conclusion is totally contrary to the intent of the license. But your lordship will recall that in answer to my lordman's, I had indicated that that 2010 affidavit had been filed. That was to meet the exact point that your lordship just raised. That is to say that the effect of this decision is that we should simply not challenge any claim.
Do you, do you
on.
submit that provided your challenge was a bona fide challenge, you can't properly say that they knew and could reasonably measure their liability as long as there was a bona fide outstanding legal challenge to it?
Well, I would go that far.
You would go, or you wouldn't?
I would, my lord. Because the section says known and measurable with reasonable accuracy. And there are two things, and it's a point that we make in our written case. Even if we are wrong on the measurable, it certainly was not known.
Not known because it was still open to legitimate legal argument.
That's my lord. Well, that's one reason.
Is what would have happened if you had submitted costs and had been given an award for 5 years and then you succeeded in your appeal?
Yes, and indeed, my lord, we raised that point in argument. Yeah. Because there had been an increase in rates to consumers, and I think that the response by tribunal members was, well, you can get that back. But the problem with that is that you would also, in order to, because the costs need to be effective within the 12 months, you'd have had to pay the retroactive. And a lot of that payment was to people who no longer worked with the JPS. It could not be undone.
Well, if you're right on that point, then the known and measurable finding can't stand, and you then come to the second question whether you fail to bring it into the Z factor because of the interpretation of managerial decision data.
Yes, my lord.
I've just noticed that, I don't know what happened to the argument, but looking at the Dr. Lloyd Barnett's submissions before the tribunal, he was seeking to answer Lord Toulson's question by submitting that what they should have done in 2004 was put in your clients the minimum for which they were liable. And page 271 to 2. So they say, start at the bottom of 272, if JPS wanted, as it did, to question the tribunal's decision, then for all practical purposes, what it's really saying is that the 5 to 10% that the tribunal said should be applied is wrong, and our percentage is the right. But JPS could therefore have proceeded to say that this is the amount which, by virtue of the concession I've made and the agreement I've made, and that aspect of the tribunal's award which I've not challenged, these amounts are amounts that in any event the company will have to pay. And there is an additional amount which I'm challenging, but in respect of which there's a possibility that the decision of the tribunal will be upheld and they will have to pay. When it made its 2004 application, therefore, those costs should then have been reflected in the application, but no segment of those costs was contained in the application. So that's a sort of halfway argument, which I suppose the logic of is that they are halfway or part-way debarred, and they succeed in part and fail in part, your clients. Anyway, it doesn't seem to have been pursued by anyone, that argument.
No, my lord.
Doesn't seem to have been taken up by the tribunal. And the tribunal has gone further than the argument on the face of it.
I don't recall this being taken up, as your lordship says.
No.
There was also, I should mention for completeness, another possibility raised by Justice of Appeal Phillips, which no side contended for, which was that what the appellant could have done is seek a stay. It could have sought a stay of the IDT's award, and therefore by that means protect its position. I think, my lord, that's at page...
How would that help?
Stay of the IDT's award.
Just going back for 1 second, I mean,
It's
one
at page
answer
three-
to
three and
Dr.
four.
Barnett's point might have been to say that known and measurable means known and measurable, doesn't mean that, well, could be,
Not
and
more
on
than.
our case is
Not less than.
X. But on the other hand, it might be X plus Y, so we'll put in X. That's not known and measurable. That's a different concept.
Yeah.
Well, the alternative argument is that X at least is known and measurable.
But anyway,
So anyway, that's a...
That's not the argument.
So the suggestion of a stay made by the Court of Appeal in paragraph 65, to which you were referring us, was that made by anyone, or was that something that the Court of
It was
Appeal...
not suggested by either party,
No, the Court of Appeal came up with that.
as I recall. Yes, ma'am.
How would it have helped?
I don't think it would have helped at all, you know, because the OER's position would presumably still be the same.
Yeah.
You ought to have put it in at the time. Whether there's a stay or not doesn't affect the operation of the clause.
I suppose the stay might mean it clearly wasn't going to be effective in the next 12 months. I don't know. Anyway,
Depends what's meant by effective.
it wouldn't be effective in the next 12 months in reality.
It depends what we mean by effective. I mean, it was always,
It was retroactive.
I mean, it was effective from 2001 in one sense.
Anyway,
So I don't see how it worked.
My lord, may I take you to the license?
right?
This relates both to the point I've been making and to the issue of the meaning of managerial decisions. At page 32, your lordships will find the price control schedule, Schedule 3, which, not the simplest schedule, but explains how the rates would be set and costs would be recovered. Now, at paragraph 2, your lordships will note, 2A says, the rates for electric power shall consist of the following components. And the most important one for our purposes is 1, the non-fuel base rate, and then there's a fuel rate and 2 other not relevant items. C, well, B deals with the rate situation for the first 3 years of the license. Then C is a relevant provision dealing with the rates post May 31, 2004. Starts by saying the licensee shall submit a filing no later than March 1, 2004, and it must include the test year, which is defined at the top of the page. But the important part for our purposes, my lord, I would suggest, are the following 2 paragraphs at the bottom of page 32. The non-fuel revenue requirement equals non-fuel operating costs plus depreciation plus taxes plus return on investment. And then non-fuel operating costs are defined as all prudently incurred costs which are not directly associated with investment in capital, plant, or the operating costs, and shall include, but not be limited to, salaries and other costs relating to employment, etc.
Yes, so you get the whole lot if they have been incurred or are known and measurable, etc.
Well, yes, but your costs, the rate should be set
Right.
so as to cover all prudently incurred costs in providing the service.
Right.
There then follows the ways in which the rates are determined. The primary item is the rate review process at 3. Then at 4, there's an annual performance-based adjustment. Then there are other minor items. There's a set of formulas, Exhibit 1, for the performance-based rate-making adjustment. And then starting at about line 30 on page 35, your lordship will see There's an annual X factor to deal with inflation. There's a Q factor to deal with quality of service adjustment. And finally, the very last item is the Z factor. And that is to capture, to include events that are not captured by the other elements that have gone before, subject, of course, to A and B. So that the structure of this license and the rate fixing mechanism is that JPS is to recover all prudently incurred costs. Here are the mechanisms by which this may be done, ending with a Z factor which says costs affect events which affect your costs, not due to managerial decisions, not captured by other elements. It is a catch-all phrase to meet the original aim of all prudently incurred costs.
If you had, for example, an agreement made in the year 2000 that in the event of a war or a trade embargo, salaries would be increased by 5%, right, to cater for the extra work, shortage of labour and so on. Or in the event of civil disturbance, salaries to security staff would go up 5%. Then that would be a managerial decision made in 2000, but it clearly wouldn't be a predictable or known or measurable cost in 2004. If a war or an emergency or a domestic crisis, a state of emergency arose in 2008, you would presumably be entitled to put that in as a Z factor point. I mean, that's the argument you would run. The argument against you would be presumably, well, that's a managerial decision in 2000, and so too bad.
That, my lord, we would say would be an argument that would frustrate the intent of the license.
What do you say was the intent of B in the Z factor?
B in the Z factor, my lord, is to deal with a decision that one makes, I'm tempted to say imprudently, but a decision that one makes which itself increases a cost, creates an event. I didn't think it was necessary for the purposes of this appeal, but it would seem to me that although it just says managerial decisions, I don't think it would be as wide as every single possible managerial decision. Because, to use my Lord Mance's example, if there was, for example, a war that broke out, there had not been a previous decision, and management made a decision that because of the war conditions, there should be an increase in salary. But
well, that's the problem. I mean, my example took a decision in 2000, but what if the decision to increase costs was in the face of the emergency, which took place in 2008? Would it be excluded from the Z factor? It'd be slightly odd. How do you distinguish the two types of managerial decision according to their date?
well,
Perhaps it means something slightly different. Perhaps it means the ordinary course of business, you just decide to restructure and have you got a solution to this?
Well, I'll make an observation, my lord. The word events, it is an increase due to events which are not due to the decision. So that it is not the costs that must be due to the decision, but the event. So that I think in the example we're discussing, the war is the event.
Yes, I see. So you say then the real cause is the war in my example.
And indeed, my lord, that was the answer I was going to give. If it were to be suggested that the decision to not include the cost, let's assume the costs were in fact known and measurable. If it were to be argued that the decision to not include them was itself a managerial decision for the purposes of the Z factor, my response would be that it wasn't, because that decision did not cause the event. That decision, the costs are not caused or increased or affected by that decision. So that it would be relevant anyway. And that's why I had difficulty in accepting.
Supposing you decided during 1 year to take on a whole lot of new staff, would that be a Z factor or not?
Well, it would not have to go on the Z factor, my lord, because...
Would it?
It would not have to, because those are costs going forward, and they would presumably be included in the adjustments going forward. What caused the problem in this case was not the going forward, it was the retroactive...
I understand
lump sum.
that. It's the back pay, isn't it?
Yeah.
Yes.
And so adjusting the salary
But
daily.
if you take you've got a year.
Yes.
If in the second month of the year,
Yes.
the company suddenly decided that it would be a very good idea if it had spanking new team of advertising staff and outreach workers and communications people and so on, all very expensive. Would that be an event which it could get into Z?
I think we
Would
would
the
then...
cost of that be?
We'd then face a challenge of what does managerial decision mean in that context, and does it cover that?
Yes.
And it would seem to me, my lord, that if it was a decision that was defensible on an ordinary course of business commercial grounds, it
Right.
ought not to be debarred.
Right. What's the event? So what's the event?
I think the event in that would be the decision.
Would be what?
Would be the obligation.
The hiring of the extras.
Can I just understand, I mean, Exhibit 1, in which the Z factor appears, is dealing with the performance-based rate-making mechanism, and it says the non-fuel-based rate for each customer class should be adjusted on an annual basis. So it's dealing with adjustments to something, it's dealing with adjustments to what you looked at, drew our attention to, namely the non-fuel operating costs and the non-fuel base rate. They include all prudently incurred costs. Have I understood it correctly? At the beginning of each 5-year period, do you make for 5 years an estimate of all your salary costs? Because, as my Lord points out, your salary may go up and down.
What do you do?
How do you allow for salary increases in workforce if your business expands?
But two things, my lord. You use the test year, use the prior year, the actual.
I see. So each year you do a recalculation.
No, my lord.
No?
No.
At the start of the rate, at the time of the rate fixing,
The 5
the 5 years,
Right, you take the test year. Fine.
you take a test year, but then there are annual adjustments. And there are annual adjustments. The formula, if you look at just below Exhibit 1 on page 34,
From 34, yes.
it says annual growth rate for non-fuel-based rates, so that there's an annual increase in the rate pursuant to a formula.
Sorry, where's that annual?
Very bottom of page 34. So that
Will be adjusted on the annual, yes.
so that the formula recognizes that during the 5-year period, there will be some increases in costs, so that there is a
Yeah, but
incremental.
do the increases in costs in fact include increases in staff due to expansion of your business? I'm just looking at top of page 35.
No, my lord, they don't.
They don't.
No, they don't.
What, so that if you're successful and you expand your business,
You would need to get the OER's approval, effectively.
you need to...
You would need to get the office's approval.
Yeah. And you need to fund your extra staff out of your extra customers, basically.
That's basically, yeah. Right, okay.
You wouldn't be entitled to a rate.
I've understood, yeah. Good.
So, my lord, that's the structure of the license. And if I may then go back to this question of the interpretation of managerial decisions and make one or two other points. The license says, if your lordships will see this at page 12, page 13. Page 13, condition 1, the interpretation starts with a declaration that the license shall be construed as if it was an act of Parliament. And that means, my Lord, we submit, that consistent with the usual well-established rule that acts of Parliament are read prospectively and not retrospectively unless they specifically say so, this provision in relation to managerial decisions ought to be so read. Now, my learned friends have said that it does not say specifically that it excludes past. And the truth is, the converse, the opposite, is the correct position. It is to be noted, it does not say it includes them.
And so you say it doesn't apply to managerial decisions made before the license.
For that additional reason.
Right.
And
your primary case, that's not a very logical date, is it? One looks at the internal scheme of the license, which seems to operate on the basis of 5-year adjustments, and the Exhibit 1 is dealing with internal adjustments on an annual basis within the 5 years, isn't it?
Yes, ma'am, that's correct.
Yes. So those are more logical dates if you're trying to draw time limits. Or...
If I may make this observation, my Lord. Prior to the license, JPS could and presumably did set its rates at figures prior to the license.
Yes.
The company could set its rates at figures that would cover all its costs, regardless of managerial decision, regardless of how they came about.
Yes, I mean,
That's the price cap regime.
I think we understand your point.
So that the price cap regime is saying, going forward, you can no longer do so.
Yeah.
Here are the terms on which you can recover. And one of them, the last one, the catch-all, says not managerial.
Yeah.
And against that background, I say, my Lord, you can't read it. That would be a retrospective reading.
You can't read it from the date of in 2004, from 1st March 2004. You said that the ban on managerial decisions only applies within the 5-year period. Is that your position?
I wouldn't go that far, my Lord. The management decision could have occurred in the test year.
Really?
It could have occurred before the 2004 rate review. It doesn't have to be in the 5-year period going forward, because the cost could have already been incurred. No, I'm sorry, madam. That's correct. No, we're talking about the Z factor.
Z factor.
Which only relates to events during the 5-year period. It could only relate to decisions during that period. Yes, that's correct.
So your argument that we have to read in a ban on retrospectivity really means that the only managerial decisions which are hit by the Z factor, you would say, are managerial decisions reached after 1st March 2004.
Yes, effectively, because it is during the period. And I hesitate, my Lord, to go that far for the reason that because we're dealing with events and causes, the event could arise during the period based on the decision that took place immediately before the period.
I see.
So I'm hesitant to go as far as to
hesitant
say.
about going that far. Okay.
Now, the statutory regulator took two approaches to managerial decision, a broader and a narrow approach, didn't it? We have it at page 124 and 125. 124, paragraph 4, Roman 3, we have the broader approach. The costs incurred were as a consequence of managerial decisions in that JPS agreed with the labour unions to embark on the reclassification exercise. And then we have the narrower approach on the facing page under Roman 8, halfway down, line 23. The IDT's decision was handed down in August 2003, and as such, sufficient time had been afforded to the company to include such salary adjustments in the 2004 tariff submission. JPS exercised the option instead to submit the matter to the courts for adjudication. This was a managerial decision.
Yes.
So far as the second is concerned, I imagine you repeat your argument that you were advancing on the first point, that to describe as a managerial decision a bona fide challenge to the legality of a ruling is unsound, would be your argument. As to the broader approach, at 124 Roman 3, you've got your temporal point. You say, we're not worried about things which happened in 2000 because that predates the license. But do you have any other argument in relation to that broader way that the regulator approached the question of managerial decision, i.e. anything which has any connection with the reclassification exercise?
Yes.
Is ex hypothesi a consequence of a managerial decision?
Yes, ma'am. I do have a further answer. In this broader construct in paragraph 4.0 on page 124, there are items, for example, items 4 and 5, Roman numerals 4 and 5, which are decisions and actions made post-license, decisions to go to the Supreme Court, the decision to appeal. The OUR describes them as aggravating the costs. And there was an issue before the tribunal as to what aggravated can mean. And my submission then and now, my lords, is that they certainly did not cause the event, first of all. And in any event, they did not affect the costs. The costs...
Well, it will have included, they will have incurred legal costs.
Exactly. But there's no claim for that.
And those would not be recoverable under Z, would they?
Correct, my lord.
Yeah.
But the cost that is being claimed, which is the retroactive payment to the workers, is not affected.
Yes.
So that would be my further answer, Lord Toulson, to this wider construct. My lord, after the written cases were filed, it came to our attention, your lordships, the board's decision in Wood and Capital Investments. It had been decided before, but was not referred to in the case. And if I may refer to one passage in that decision. That judgment, my lords, is at tab 16 of the authorities bundle, at page 897.
Sorry, page again?
897, my lord. The judgment starts at 897. And I would take your lordships. I may take your lordships to paragraph 11.
Paragraph 13.
11.
11.
My lord.
I do beg your
At
pardon.
page 901. No, after pointing out in that paragraph that interpretation is a unitary exercise and that the court can weigh implications of rival constructions by considering which construction is more consistent with business common sense, Lord Hodge went on to observe in paragraph 12 that the exercise involves checking each suggested interpretation against the provisions of the contract and investigating its commercial consequences. This approach, my lords, we submit, supports the construction for which we contend, for this reason. On the respondent's construction, the commercial consequence would be that an expense which nobody has suggested was not prudently incurred for the purposes of provision of the service. On their construction, that expense would not be recovered in the way envisaged by the license. Now, the appellant's construction, the commercial consequence would be that it would be recovered in the way envisaged by the license. And I say, my lord, that is a final consideration I would urge the board to consider.
So how are you in fact seeking to recover it? You identified it in 2009, which happens to be the last day of last year of a 5-year period. So, and I read somewhere in the documents that you propose to amortize it over 2 years.
Yes.
Right?
Well, that proposal, my lord, was based on the OUR's approach. The OUR would then determine how it would be spread out. And that I know is a matter for them.
I see. So what are you suggesting would have to go back to the OUR? For
Well, my lord, if I could take your lordships to the fixed day claim form and the relief that was sought. That is at page 294. The order, because it was a judicial review of the tribunal, and the tribunal you will see at paragraphs, after the declarations at B, the order at paragraph C would have directed the tribunal to reconsider the matter and make a new decision.
Yes, I see.
Now, the tribunal, as I pointed out earlier, had the option of either modifying the decision or sending it back to the OUR.
So, I mean, you're accepting the tribunal's function of decision-making. The tribunal itself could refer the matter back to the office, couldn't it?
Yes, or modify it. So what I'm accepting
Yes,
is that the court's function is more limited.
It's slightly unsatisfactory, perhaps, if we don't have a clear view as to what the role of the tribunal is. And you say it's decided that the word modify it gives it, what, pretty broad powers, but I wonder, in context.
May I say, my lord?
It may be like the upper tribunal here, that its jurisdiction is limited to dealing with errors of law, but once it's found an error of law, it doesn't have to send it back. It can decide that it can deal with it itself, and indeed hear evidence for that purpose. But, or it can send it back, so that, I mean, that would, I'm not sure whether one gets that out of the wording here, but it seems to be fairly clear that here the initial intention is that it should have a power to review on judicial review grounds only, and it's only if it finds a judicial review error that it can then decide, well, do we modify it? Have we got the material necessary to modify it, or do we send it back?
Okay, well, that's...
I think, I mean, that's how I would read it.
Well, my lord, I wouldn't go that far, because
How far would you go?
I mean, we can't confer. We've got to be... Yes, carry on. Let's have your submission. We've got to be a bit careful about...
I mean, as far as we're concerned, we're all simply being asked to send it back to the tribunal, and they will decide what to do with it. But
and my lord, that it may be that the matter would inevitably have to go back to the OUR because of the issue that your lordship raised, as to, even if it were to be decided that the sum was to be recovered, the OUR would have to determine over what period and
yes,
so on.
there's issues of that sort.
I would certainly not be able to invite the court to deal with that.
And you say that they could run this into the next quinquennial review. So the next quinquennial review would be done on the usual basis, ignoring these, but then there would be, so to speak, an overlay of these costs.
No, I think, my lord, that the way they do it is that when there's a Z factor claim that is allowed, they do a separate...
yes, that's right. The Z factor would be a separate claim, but you could have a Z factor hangover from the previous quinquennial review or previous quinquennial period of 5 years.
Yes, well, it doesn't tie to the quinquennial at all.
There are two quite separate questions, aren't there? One is what costs can you recover?
Yes. And how do you...
And the second is how do you adjust the tariffs to enable you to recover them?
Exactly.
And we're on the question, we're on the first. We're on whether the money the back pay that you paid out in 2008 is recoverable at all. If it is, it's for the office, the regulator, to work out how you adjust the tariffs and over what period to recover the money. Is that right?
That would be my position, brother.
Yeah.
But in answer to my lord, I don't think it is at all tied to the quinquennial, to the 5-year periods. They started from from the event. So there's an event, there's a Z-factor claim, it is allowed, they start a recovery period, which may or may not overlap.
Yes, but the Z factor, I think my point is that the Z factor is a factor which enables you to adjust future costs by reference to past costs in this case. Isn't it? I
Yes,
mean,
it is. Yes, my lord, it is. But
so the truth is you could be adjusting costs in the second quinquennial period by reference to costs going back to 2001.
You can adjust tariffs in the next
Yes, sorry,
5
tariffs,
years
tariffs.
by reference to costs incurred in the past.
Yes, tariffs. But although Exhibit 1 actually refers to adjustment on an annual basis, we were speaking of it previously as referring to adjustment on an annual basis within the 5-year period, but it would be very odd if that couldn't run into the next 5-year period. All right.
my lord, just for completeness, I'll just mention that, your lordships, we asked that 2 cases be handed up, National Commercial Bank and Hugh, and FIS and Negril. And those are only, my lord, for the purpose of indicating circumstances in which the board has in the past departed from concurrent findings of fact. And
Departed from what?
concurrent findings of fact in the courts below. And if I may just, perhaps your lordships can just note the paragraphs. I don't think I need to take it to them. In the National Commercial Bank,
But I mean, yeah. I mean, this is an issue of law, isn't it, my reading?
I think so, my lord. This is not an issue. There was no oral evidence. There was no issue of demeanor.
Well, the
Agreed documents.
What's said against you, rightly or wrongly, is that there's a finding of fact that you could have included, you could have done the exercise in 2004. And I think what's said against you is that both the regulator, the office, and the tribunal have reached that conclusion. After that, it's a question of law. There's no question of findings of fact in the High Court or the Court of Appeal, or at least there shouldn't have been. But I think that's the way it may be put against you.
But we've never treated concurrent findings by a regulator, have we, as being...
This is not a...
We're talking about concurrent findings of courts, not of...
It's not a, well, yes, it is a finding.
I think that as I understand it, the respondents argue,
Except the upper courts have signed points of law.
I think the respondents argue, my lord, that both courts below accepted the tribunal's
Yes,
findings. So
but insofar as they were going into questions of fact, they shouldn't have been. Anyway, I mean, I think we know the principles, don't we?
But you wanted to give us paragraph numbers in judgments.
in the National Commercial Bank case,
Yeah.
I refer your lordships to paragraph 41.
41.
And in the Financial Institution Services case, I refer your lordships to paragraph 32.
Sorry.
Sorry, 31 and...
41 and 32.
41 or 31?
41 and 32.
Well, it's not...
So if there's no evidence to support the concurrent findings of fact, then this court can say so.
And should say so. Respect.
Because in that event, there's an error of law.
My lord?
In that event, there's an error of law.
It doesn't error. Exactly.
Yes, precisely.
My lord, unless I can assist the panel further.
No, thank you very much indeed. Mr. Powell. Yes, Madam Attorney General.
May it please you, my lords. My lords, in light of how the arguments have gone, the counsel for the fifth respondent and myself had agreed that in the interest of time, I would focus on the first issue and Dr. Barnett would focus on the fifth issue, seeking your guidance as to how you would want us to argue.
So just tell us which you identify as the first. And
The first agreed issue has to do with the interpretation of managerial decisions.
I see. Well, it might be more helpful perhaps to hear Dr. Lloyd Barnett then. What do my colleagues think?
Yeah.
Yes.
Grateful.
Thank you very much indeed. Yes. Dr. Barnett.
Please, my lords, the first preliminary submission I would like to make is that this was a rate-fixing exercise which is concerned with a monopoly which has the sole distribution rights in Jamaica. And the increase of electricity rates have far-reaching economic implications. And the license was
About 0.
negotiated and drawn up against that background,
Right.
which explains the somewhat rigid rate-fixing mechanism which your lordships have been looking at. And as your lordships would have seen, the rate-fixing mechanism is controlled by the third schedule, which provided initially for the submission of the first application by the 1st of March 2004. And it provided, as my learned friend has indicated, for successive applications every 5 years. The Z-factor mechanism is intended to deal with random situations. In a way, situations which are not normal or not predictable. And in the provisions relating to the rate-fixing mechanism in the license, the Z-factor mechanism has 3 conditions, as your lordships have seen. And it is my respectful submission that those 3 conditions are independent and all 3 have to be satisfied in order to qualify under the Z-factor
Right.
mechanism.
Yeah.
Because it sets out each as to be called, and it says and not or.
Yes. I don't think that's an issue.
And therefore, it is very important that, and we respectfully submit that it should be recognized that they both have to satisfy, that is, JPS has to satisfy both that the event was not the result of a managerial decision.
I thought we were dealing with the first.
I am just indicating that we are not conceding.
No, I think we're going to hear from the Attorney
Yes,
General.
sorry. Yes, was and
You know where you stand on this.
Now, in the Z-factor application, the application has to state the test year and the non-fuel operating costs for those years, and those, as you have noticed, must include salaries of staff. The issue, therefore, is whether, as of March 1, 2004, the salary structures resulting from the job evaluation had been sufficiently settled to be known. And we submit that the respondents had sufficient information, the appellant had sufficient information to calculate from those salary structures.
In principle, you accept that if that's right, then they could, and you say should, have included them then.
Yes, sir.
And they would have recovered them.
And they would have recovered them then. So it is not a question of the license seeking to prevent them from recovering, but providing the mechanism by which recovery is obtained. Now, at no stage before the IDT, or when the decision of the IDT was first challenged, was it being suggested that the Pete Marwick report did not provide the data on which the calculation could be made. This was something which was raised subsequently.
Well, is that right? If you look at the submissions made to the OUR, if we just look...
No, my lord, I'm not dealing... That is subsequently, when the rate was being applied for. But at the time when the first challenge was made to the ruling of the IDT,
oh, I see.
Because that matter went to court.
But the issue wasn't relevant then, was it?
Well, it was relevant because the IDT is required in law to settle the dispute, and therefore it had to fix the wage rates which were being claimed.
But it concluded that it couldn't, and that there should be an exercise involving the oversight committee and the consultants.
This is not, with respect, correct, because what the IDT said we look at page 52. First, the dispute which was referred to the IDT is recorded at the top of page 52 of the record.
52?
Yes, sir. And what they were required to do is to make a determination as to the salary structure, which should be implemented as a consequence of the job evaluation and compensation review exercise. And the dispute which arose is described in that ID2 report. The company's position was that the calculation should be done not on the basis of the top 4 percentile, but on the basis of the 11 companies in the survey.
Yes, the issue was the comparators.
Indeed, my lord. And not that the figures were not available.
Well, it didn't matter, did it, whether the figures were available or not? All the IDT had to decide was the issue of principle. No?
That was all the IDT was asked to decide.
Quite.
In other words, the company did not raise an issue.
Well, if you look at the foot of 63, page 63, they discussing the job evaluation and compensation review exercise again.
Yes.
And it says, the exercise, last 2 lines, went successfully up to the completion of the ranking of the jobs and establishing internal relativities. And then over the page, it says, the major part of the problem began when a monetary value was to be attached to the jobs. And the management's approach in this respect was unconventional.
Yes, and that's a very important remark, because what the IDT was saying...
Just read on, though. It then says there's much work to be done to establish, to restore the credibility.
Indeed.
The oversight committee has to be reconvened. Consultants should be part of it. And then it cites some theoretical work as to why you use consultants, the first element being involvement in the task of revising the wage structure. And it says at 20, there may be need for the outside specialist assistance to deal with any complexities that may arise, so as to avoid unforeseen anomalies and assist in restoring the credibility of the participants.
Yes, and the whole of that passage, my lord, is concerned with the IDC's anxiety that a very tense industrial relations climate should not be adversely affected in the implementation exercise.
So your point is that the IDT is not simply deciding the point of principle, it's acting as a conciliation agency as well.
Indeed, and if you read further,
in settling the industrial relations.
Indeed. And if you read further, you'll see it puts it as a recommendation, not as part of its award.
Yes.
And the quotation, which my learned friend referred to but did not read, is a quotation which deals with making sure that the exercise of this nature is implemented in a way which conduces to a friendly and settled industrial relations climate.
But can I just ask, I mean, if it was all so clear, it all seems a bit speculative as to how much work was involved. Nobody seems to have actually looked at the work which was later done in any detail. But if it was all so clear, shouldn't it have been included in the audited accounts for 2003, for example?
We submitted it should have. It's a failing on the part of JPS not to have included it, because JPS was consistently acting in, as the IDT says, in an unconventional manner. They first of all...
But who were the auditors? I mean, JPS are not the auditors.
Oh, but they were not provided with the details. They were not provided with the IDT award.
How do you know? Who's investigated this? Nobody seems to have looked at the audited accounts.
Yeah. My friend maybe can tell, but my instructions are they were not provided with the IDT award. Yeah.
When do you say that the relevant costs became known and measurable with reasonable accuracy?
They became known and measurable when Pete Marwick delivered its final report.
So, and the date of that was?
And the date of that was June of 2002. Yes, June of 2002. That's on page 51 of the record.
Page which?
51.
Thank you.
Before the IDT decision.
Yes, a year before.
Yes, that
Yeah,
was.
yeah.
Because they gave evidence, and it has to be recognized that the Pete Marwick report was before the IDT, and they gave evidence, as did Hamilton, the consultants.
Pete Marwick's report proceeded on the basis of what the IDT concluded were the wrong comparators, didn't it?
No. The Pete Marwick report gave, as it was required to do, it did the benchmarking in the market, and it did it for the top 11. And
For the 11 who responded to the survey?
Yes.
The top 11, I don't think.
But
There were 17.
Those are the wrong comparators, aren't they?
No, but it provided in those salary scales, it would be possible to see which were the first 4, as well as all 11.
I see.
Yes.
And so that the company's position is not that it was not clear or was inaccurate. The company's position is that the calculation should be done on an average of 11 rather than of 4.
Yes, that's the comparator point. Yes.
So what is your submission that the company should have done?
And therefore,
it should have charged the population of Jamaica on the basis of the
top 4.
The top four.
The top 4.
So it should have charged the full whack, i.e. the increased.
Yes.
And what if it had won the appeal?
If it had won the appeal, then that means that they would not have or would not be required to pay the workers because they were paying retroactively.
So
they would not be
pure
required to pay
profit.
the full amount.
Be pure profit for them, would it?
Well, it might not, I suppose, because it might there might have to be a tariff reduction. But how realistic is that? Once they've paid all their workers, how are they going to get the money back?
Yes.
Well,
I think you were suggesting...
I'm not certain it is that one should be proceeding on the basis that somebody who lost, what would have happened if they had won? They've lost right through.
Yes.
Can I, I quoted earlier, before the tribunal, I think it was before the tribunal, you were arguing a rather subtle, differentiated scheme. You were suggesting that what they should have done was charge at least that amount which they were prepared to accept and not include the rest until they lost in the Court of Appeal. So would the rest then have fallen within the Z factor?
So much,
would the rest then have fallen within the Z factor?
I'm not sure it would, but let me just go back. I'm not sure that my argument was exactly that. I was saying that if they were acting in good faith, since they knew that there were some specific costs which they would have had to incur, namely the cost of using it on the basis of 11, they said that there were 500 persons they conceded who were being paid below the minimum, and they would have to pay the 11 case. Yep. As I was saying, that those costs, which they were not contesting in any event, they should have included.
But what would happen, okay, if that had been done, what would happen if they ultimately, as they did, lost and were told to work on the top 4? So they would then retrospectively have to pay more. How would they recover under your analysis the more that they later paid?
If they had failed to pay at the time or denied a liability to pay at the time, then it would have been their error in having done that. Because once they paid and accepted the liability, they would have been able to include it in the 2004 application.
Basically, they've got to concede in order to recover these costs. They shouldn't challenge the appeal. They shouldn't go on appeal.
Or at least if they do and lose, they take the consequences.
Yes, yes.
Is what you say.
Yes, indeed, and not the public.
So it is right, there's no mechanism to, in your submission, for them to recover the excess.
If they have failed to make the application, or to have included it in their application.
I mean, if it had been found, contrary to what was actually found, that they could not reasonably estimate the relevant figures in 2004, and therefore they were entirely justified in not including it in those accounts, what is the mechanism, in your view, or is there any mechanism for them to include it in the following period?
No, I do not think there is a provision in the license for the recovery of costs which you have failed to include.
Even if you were perfect.
And you ought to have included it.
But even if you were entirely reasonable in the sense that because you weren't able to calculate and then you didn't have the relevant information, so you were perfectly justified in not putting them in that year, you say you just lose it, do you?
Because let us take a case which is not so controversial. If the company's accounts had gone wrong for some reason, and there were some costs that they had incurred, which was not included in their rate fixing application, and the rates have been fixed, and then 2 years afterwards, in the midst of the 5-year cycle, they decide that, having found out that they had omitted a cost, the mechanism does not provide a method for them to have included it in a Z-factor application.
They have to live with their mistakes.
Indeed.
They also have to live with their non-mistakes, because even if they've acted entirely reasonably.
Well, if they have been wrong, I prefer to say if they have been wrong, because the courts have said that they were wrong. And those decisions are binding. You see, the IDT decision as a matter of statutory provision was binding on them immediately. And the fact that they appealed only gave them an opportunity to set it aside on the judicial review grounds, because the IDT decision can only be challenged on the judicial review grounds, and so that decision stood unless they were able to set it aside. I would therefore respectfully submit that speculation as to what might have happened if they had won does not really assist in the interpretation of the license.
Where's the OUR's finding about the ability of the company to make this claim in 2004? Where is it in the decision?
Of the OUR?
Yes, please. Yes, because that's the one that.
Yes, that's the first one that dealt with that specific issue.
125. It's page 125, isn't it?
The 117.
It's the second half of Roman 8, is it, on page 1?
Line 24, the IDT decision handed out in August 2003, sufficient time been afforded to the company to include salary adjustments in the 2004 submission.
Yeah, but where's the finding that they could, that it was measurable?
With reasonable accuracy.
Reasonable accuracy.
That's it.
They deal with this in and I think in 8, Roman 8, lines 19 onwards, they start with making reference to the definition of test year.
Well, what your clients say, the office, the regulators say, these costs, if legitimate, which is not conceded, why not? How could they be anything but legitimate? I mean, there's a separate question of whether they ought to have been in the earlier quinquennium, I understand that, but how could they be anything but legitimate?
But this wasn't the basis of their decision.
Well, I know, and that's why I'm asking. Why did the OUR say that there was any question about that?
I don't think there was any representation before the office, and
there wasn't.
Not aware of the reason why that bracketed portion is included in the statement.
But it looks as if the regulator really wasn't very convinced about the claim at all. Never mind its timing.
It's odd to find a regulator talking about what is conceded or not conceded.
Anyway, there we are. Anyway, let's leave that. You don't know, and we don't know.
Yeah.
But what they go on to say is, ought to have been submitted with the 2004 tariff submission. You say, do you, that necessarily includes, must implicitly amount to a finding that it could have been measured with reasonable accuracy?
Yes, the penultimate sentence in the paragraph suggests that there was sufficient time to include the salary adjustments in the submission. Therefore,
certainly.
Therefore, one must assume that they are accurate.
Well, and one has to bear in mind that the question of inadequate information was raised at a later stage.
Well, no, you see,
No, that's not right.
Turn back to page 101.
Yeah.
Well, 96, actually. '96, Roman 3, the cash flow impact had not yet occurred, the timing of the payment was not known, actual payment occurred in 2008. Hence, in effect, they are saying,
this is a
we've put in our Z claim now.
And actually, in 97, unfortunately, no provision could have been made in the audited financial statements prior to 2007.
Yes.
There was total uncertainty over what impact the job reclassification exercise would actually have on salaries.
Now, what I'm wondering about is where the office has dealt with those arguments.
But this is the preamble on page 97. So
this is the claim that the regulator was adjudicating upon, isn't it?
Indeed, I'm saying that the preamble to that claim on page 97.
That's it.
Which they are advancing the argument there that it was the impact of the salary increases were known. But then they go on to say, if your lordships look at line 16, 17, moreover, the issue was before the IDT Tribunal and subsequent to the courts was not one of quantum, but rather surrounded the compensation philosophy to be used in completing the compensation review exercise. In fact, the management which obtained under the new majority owner contested the use of a philosophy which had been used in 1990-91. So they confirmed that it was not really an issue of quantum that they were.
No, but they've already said on page 96, as my lord points out, actually in little 1, the financial impact was not known with certainty. This was due to the fact the actual sum was being determined by independent consultants commissioned by an oversight committee in accordance with the judgment of the ITT affirmed by the judgment of the Court of Appeal. That's in 2007-8.
But my lord, they explain why they say that, which is what I've already submitted on this, saying that it's because the IDT had asked the oversight committee to participate in the matter. And I've already submitted that what the IDT had asked was for a public relations, industrial relations exercise to be undertaken, and it had nothing to do with the adequacy of the figures or the calculation of the amount.
Yeah.
That was in order to prevent any further industrial tension, which had existed for some time in the course of this wage negotiation.
The office's treatment at this point strikes one as perhaps rather brief, doesn't it?
It is, my lord, but in the final analysis, what has emerged is that the existence of the data which Pete Marwick provided and which was held to be adequate for the calculation to be made.
It took a year to deal with the question from the submission. Is there any evidence that it went back to the company and challenged the company's statements? As far as one can see, there isn't.
No, there's no evidence on the record of that. But I think at the end they did say that the costs were legitimate operating costs, that line 30 on page 97.
Yes, they did.
And
Yep. Well, the office doesn't even appear to have accepted even that.
and that is not
To have
in dispute. The
conceded.
question is, how do you recover it, and at what stage?
Yeah.
So that, as we have seen, my lords, what was referred to the IDT was a dispute as to what part of the structure, the salary structure, should be adopted or not. And the tribunal specifically awarded that it should be the top 5 to 10 percentile. And some measure of credit has to be given to that because of the fact that the IDT would have had and did have the Piedmont report, which the courts did not have in the subsequent proceedings. And they heard from the consultants. So that, as a matter of law, that award was immediately binding by virtue of Section 12 of the Labor Relations and Industrial Disputes Act, which is at tab 2 in the Bungalow Authorities. In Section 12.
Section 12.
Of the,
yes,
which is on MS 560, page 20 of the statute. Article Section 12, these are the awards of the tribunal. And 12.4.
Sorry, I'm not with you. Which page are we on?
Which page are we?
tab 2, page
Of the authority.
560. 560.
Labor Relations and Industrial Disputes Act.
Page
560 at the bottom.
560, is it?
560. This is the, yes, the tribunal.
Which provides that the award may be made retrospectively, shall specify the date from which it shall have effect, and shall be final and conclusive, and no proceeding shall be brought in a court to impeach the validity except on a point of law. And then in 12.6, on page 563, award in respect of any industrial dispute refer to the tribunal for settlement, and any decision given under subsection 10 shall be binding on the employer, trade union, and workers to whom the award relates. And there was nothing advanced before the IDT, which gave a fairly full report on the proceedings before it, that any new survey was being applied for. And the IDT clearly treated the survey which had been done and completed by Piedmont as complete and as the basis for the classification and the calculation of salaries. And what is important to note is that the IDT held that JPS had unilaterally decided to alter the pattern which had been agreed on between the parties, and this is at page 64.
So does the point about the IDT's award being binding explain the reference which we looked at earlier to a possibility of a stay? Is the point that was being made somewhere along the line?
Yes, the Court of Appeal mentioned that possibility.
Yes. Is the point that was being made somewhere along the line that appealing the IDT award does not operate as a stay, so you're stuck, so you have to implement it?
Yeah. That's a statutory provision. I suppose you could, and they did apply for mandamus, and they could probably have applied for some, I'm not sure. Could they had already decided, so prohibition would not have helped them. The decision had already been made. They had submitted to the
How
jurisdiction.
would you get the stay?
It's judicial review anyway.
Judicial review.
It was not something that we had applied for, as my friend conceded. It was something that the Court of Appeal mentioned.
Yes.
But it was, the strategy of JPS was clearly to avoid the implementation of the award. And to continue its challenge to it. And so long as they were doing that, it is clear that they did not wish to comply with any part of the IDT award.
But I mean, that's not relevant to the issues before us, is it? I mean, you're not challenging their right to appeal, and they accept that they have to implement the award. It's simply a question of how it fits into the statutory scheme.
But I'm challenging their right to ignore the award. That is to...
Wait a minute.
I'm challenging whether they have any right to
Ignore it.
ignore the award. I'm saying they have an immediate legal obligation to comply with the award.
They couldn't, because the order required certain things to happen in cooperation with the Oversight Committee.
Well, the order didn't, the recommendation.
Well, my
There was
Lord,
a
I've already
recommendation.
stressed on
You're distinguishing the award from the recommendation.
There was a recommendation that, and they gave the reason that it was in the interest of good industrial relations atmosphere that the Oversight Committee should act in the matter and deal with any problems that might arise. But that was not part of the award. It was a recommendation for which they gave the reason on the basis of a text which they quoted.
I'm slightly struggling with this because it may be my fault. It seems to me to be a new point in the case. I think you're saying that there was an immediate legal obligation to comply with the IDT's award, whether or not they challenged it by JR, and therefore, you say, the consequences of that award were reasonably calculable or sufficiently measurable that they ought to have gone into the tariff review. I'm not sure that any of the courts or tribunals have actually put the matter in that way, have they?
I think the office did say that they delayed the matter, or words to that effect. But the fact of the matter is that they did spend some time in the legal challenges which they mounted to the award, and that those challenges were not upheld.
I suppose that's effectively what's being said at page 203 by the Tribunal, paragraph 35, saying that they didn't activate the Oversight Committee, there was nothing to preclude them from calculating the costs themselves. And it says the regulatory scheme did not permit them to ignore its provisions and seek repayment outside the period. So what it's saying is their failure to activate the Oversight Committee and so on is not an excuse for them not to implement the award.
Yes. And that adds to the point I was making, that their own frustration of the process could not be used as a means by which they divert from the rate fixing mechanism.
Yeah.
Because it has to be voluntary. It's not an order which, as the order which was made by the IDT in the form of the award was binding, which had to be complied with. They could, as they had done previously, if you look at the IDT at the IDT report, it indicated that there was a period when JPS frustrated the work of the review committee, the oversight committee, so that although this recommendation was made, it could not really be taken any higher than a recommendation. And the appellant's contention that the oversight committee was responsible for doing the calculation and that there would be no really final obligation until that had been done, I respectfully say that this is not the legal position. And at page 64 of the record, you will see that the IDT specifically found that the JPS had decided that it would not comply with the earlier agreed position of using the top 4 percentile of the market.
Where's that? Which page?
64 now.
64.
No, not 64, is it?
No.
And I think reference has already been made to that. And the very top, the major part of the problem began when a monetary value was to be attached to the jobs. The management's approach in this respect was unconventional, and that is referring to the fact that they had not participated in the reactivation of the oversight committee. But their legal position, I respectfully submit, is that the failure of the oversight committee to meet or to make any conclusive recommendations, whether the fault of JPS or not, could not diminish the legal responsibility to conform with the IDT award, or remove the fact that a legal obligation to make that payment existed, and we submit was quantifiable. And this is what was decided in the Court of Appeal. The first judgment, a short judgment, was given by Judge of Appeal Panton, as he then was, and on page 75. It said that...
Do we have in the record the application for judicial review of the...
First IDT, is that?
Of the IDT award?
The IDT, yes.
Yeah, we don't have the application, but the judge quoted the grounds on which the application was made.
Where does he do that? Oh, I see. Yes, page 71. Is that it? Yeah.
And as you'll see in the second ground, it was a denial that there was any agreement, such as the unions were contended for, that there was an agreement that the compensation package should be linked to the first 4 percentile. The company repudiated that, and that is why the decision had to deal with that issue.
Did they seek a stay? It's not clear.
I'm sorry, my lord?
Did they seek a stay pending determination of the judicial review application?
I've seen no indication that they did, and the judgments make no reference to that, to an application for stay. Yeah. Yeah. And I respectfully submit that if there were grounds on which it could be said that the award was not capable of implementation because the results could not be quantified, then that should have been a ground of the application, and it could be set aside on the basis that the tribunal had failed or had stated something which was uncertain or incapable of.
So this should be a ground for what?
For the in the judicial review application.
To whom? The second judicial review?
No, the first one.
The
When
first
the
one.
Industrial Disputes Tribunal made the award,
I'm not following that, Dr.
No.
Barnett. Why, if what they're really challenging is the comparator question, are they also obliged to add in a complaint about what you've called the quantum, the calculation?
they're saying that the award is not. If they genuinely feel that the award is not capable of implementation and the legal liability, in fact, failure to...
That wasn't their point.
I know it was not their point, my lord, but
I
we are
see.
measuring their behavior.
I see.
And if you fail to comply with an award, it's actually a criminal offense. So that it was very important, if they feel that it was one which was not capable of compliance, that they should have challenged it on that ground.
So the absence of challenge shows that they knew that they could calculate it if they had to.
That's the point of it.
I see.
You say it's a criminal offence. That's in the Act, is it, somewhere?
Yes, my lord.
Where is that? Offences, it's in section 13.
Section 9 on page 24. Subsection 9 of section 12.
Yes, 12.9.
564.
564.
Page at the bottom, yeah. Any person who fails to comply.
That creates a dilemma. I mean, what do you do if you're applying for judicial review? How do you deal with this problem?
Well, you could apply for prohibition for not prohibition, but you could apply for an injunction against anyone enforcing it.
But is that a problem? I mean, we haven't got the judicial review procedure here, have we? But there may well be a provision for suspending the order pending a decision. Is there?
I don't think there was any. That's not mentioned anywhere. And
Well, I mean, you may not mention no one did, but I wouldn't be surprised to find somewhere.
I don't know my friend can help, but let's go. You mean if, no, you guys know where that was applied. You can apply.
Well, there must be some way of enabling people to have access to justice by way of an application for judicial review.
I think we agreed that you can apply. I mean, clearly, if you're going to
Well, you can clearly
face...
apply, but it can't be at risk of committing a criminal offence. I mean, this is a completely new point as far as one can see
Yes,
in the case.
my lord, I completely agree. The point I was making is they had not applied for any measure of relief of that nature. Not that they should be unable to or that they are unable to.
We don't know whether they did or didn't. Maybe the parties were content to let things...
I mean, the unions didn't apply to
Right.
commit them or to prosecute them or anything, and presumably the unions are on the ball.
Yeah.
It strikes one as a little, well, I won't say more.
But I'm not sure that this is an important point, certainly not a point I'm pursuing.
Well, I thought it was a rather important point for you, which is why we've been paying attention to, paying close attention. This is potentially a freestanding point that even if the UGT's decision was subsequently found to have been wrong, nevertheless, it carried legal force at the time when it was made. There was no application for stay. It was perfectly within the power of JPS to have made a reasonable calculation of what the financial consequences of it were. Therefore, having not applied for a stay and being under an immediate legal obligation to comply with it and being capable of producing a reasonable calculation, that is the end of their complaint. Now that's emerged in the last few minutes. And I must say I didn't get it from any of the judgments below, nor indeed from the printed cases. Now, if you say it's actually not really part of your case, then we can put that to one side.
What I submitted, my lord, is that we are looking at the extent to which the conduct of JPS was consistent with a conclusion on their part that the material they had was incapable of providing the methods of calculation. And we're looking at the various things which they might have done if they felt that that was the situation. And one of the things that they would guard against is that they were open to being prosecuted in the face of an order which was incapable of compliance. So that is the point I was making.
It doesn't seem that anyone is likely to have been thinking in those terms at the time. In other words, no one was threatening prosecution. Nobody was seems to be worried about that. And I'm not sure how much light it really throws on the question whether the costs were actually identifiable at that time.
But indeed, my lord, I accept that. But clearly, a far more important point is that the issue as to the adequacy of the data was not raised at that stage. And clearly, that is something which, if it resulted in an uncertain award, or an award which cannot be implemented, that is one of the major and first ground of challenge.
Well, they may well have seen the industrial tribunal as accepting a degree of complexity in working out what the award was, and they may well have felt that encouraged them to take some time to instruct the oversight committee and the consultants. Who knows?
But they did challenge it.
They certainly also challenged it.
Yes, they didn't. The whole point is they didn't instruct the oversight committee. They made no efforts to implement at that stage.
Right. Well, maybe it would be a good idea to resume this at 2 o'clock and look forward to hearing further from you.